Good evening. This is the Wednesday, September 20th meeting of the Town of Shelburne Development Review Board. I'd like to call the meeting to order. And first item, as always, is public comment. If there's someone here who would like to mention something that is not on the agenda this evening, now's the time. I don't see anyone, so I doubt that's going to happen. Secondly, we'll go to the approval of minutes. The first one is the August 2nd meeting. We've had trouble getting this one passed because of the lack of sitting members and present in the meeting, but I have read them over. I did watch the recording of the meeting, and they seem to be fair and accurate. So I then would make a motion to approve these minutes with the notation that only 3 members that would vote tonight were actually at the meeting.
I'll second that.
All right. Any discussion? All those in favor?
Aye.
Anyone opposed? Okay. All right, just abstaining. I believe the next one is September the 6th. Does anyone have any comments or edits of the September 6th meeting minutes? No. Would somebody care to make a motion to approve these minutes?
I move that we accept the minutes as drafted.
Second that. Any discussion? All those in favor?
Aye.
Anyone opposed? No. Just abstaining. Okay. Does anybody have any conflicts of interest or ex parte communication they would like to disclose? Okay. So that takes us to item 4. I guess, no times on this. Well, 7:15, we're a little early. Is the person, is anyone here regarding item 4, the design review application, Terry Price?
Not sure that anybody was
I don't think anybody was coming. It seems pretty straightforward.
Yep.
So this then is a application for a design review approval for roof repairs and new asphalt shingles on a home at 787 Falls Road. It seemed to be in order. It's been approved by the HP and DRC. So does anybody have any comments regarding this application? I don't believe there's anyone in the audience with anything to bring up on this. So I then would move that to make a motion to grant design review approval of application DR 17-13 for roof repairs and new asphalt shingles at 787 Falls Road with the following conditions. A zoning permit should be required prior to commencing construction. Seconded. Thank you, Ian. Any discussion? All those in favor?
Aye.
Anyone opposed? Okay. So the next item is relative to application SUB 16-02, which is an application by Snyder Custom Homes for a preliminary plan approval. This is the lot on the west side of Spear Street, adjacent, or part of the Quiniauska Golf Club, Country Club. It is in the residential district, stormwater overlay district, floodplain, and watercourse overlay district. The applicant has requested a continuance of this hearing until October 18th, 17. Anybody like to make a motion to continue this hearing?
I move that we continue the public hearing relating to the application SUB 1602 for preliminary plan review by Snyder Custom Homes until October 18th, 2017.
Second.
Any discussion? All those in favor?
Aye.
Aye. Opposed? Okay. So, That takes us to item 6 on the agenda, which is application A17-12. This is an appeal by Nathaniel T. Burris of an assistant zoning enforcement officer's denial of an application for a building or zoning permit for a residence at 499 Beaver Creek Road. Property is located in the residential district in the stormwater overlay district. This hearing will be conducted on the record pursuant to 24 VSA 4471B. We're changing horses here, and I probably would like to just get the swearing in over with now at this point. I'm going to swear, I'd like to swear anybody who's going to testify this evening, I'd like to swear you in. So if you please stand and raise your right hand. I hereby swear affirm to tell the truth, nothing but the truth under the pains of perjury. Thank you. So the purposes of this is to gather evidence and testimony with regard to this appeal. And Dean will be acting as the staff member for this, since Caitlin is involved with the appeal. So our normal course in this is to let the appellant kick the meeting off and start their testimony and presentation to us. So if you would please use the microphone and identify yourself.
Would you like this one?
That
or
microphone is fine, sir.
All right. So my name is Nate Burris. This is my wife, Celeste Burris. We live at 499 Beaver Creek Road in Shelburne. We've been there for just a couple months now. I actually grew up in Shelburne. I first moved here in 1984. And I actually worked in this building in the maintenance department to help pay for college. I mowed the ball fields and the parks and vacuumed around the building from time to time. We were living in the Boston area for about a decade and recently moved back for a job I obtained. And we searched for a house for about 6 months. One of the factors that was important to us in determining where we would live was whether there would be ample space for our dog and also for our 17-month-old son. We're also expecting another child in February, so we hope to have 2 children running around the yard, and that was a big factor in deciding where to buy. So when we saw 499 Beaver Creek go on the market, we spoke with the sellers, and we explicitly discussed permitting. They mentioned that there is a shed that they had obtained a permit for just 20 feet from the rear boundary line, and we also spoke with the neighborhood association. This is all in advance of buying the house, to get approval for a fence. We worked with the sellers to have a fence company come to the house before purchasing it, to develop a site plan and a proposal. And the neighborhood association approved the plan. Our 2 abutting neighbors approved the plan. Knowing that there are, of course, bylaws, I researched the bylaws. It appeared clear to me that a fence was permitted, and we ultimately purchased the house. Of course, the permit wasn't granted, and now we're here. So that's sort of the backstory as to how we came to this point. I guess if I can give you a summary, assuming this would be the appropriate time to give you a summary of my position and my read of the bylaws, and it might make sense. I have a number of exhibits. If I can distribute those.
Yes, please. Yeah, we'd like to admit these into evidence for the record. How's it labeled?
Identify each one?
Sure, I'll just go through each and identify it, and then I'll formally move it into
That's
evidence.
fine.
So,
We'll read this into the record as being entered as evidence.
of course. So exhibit number 1 is the town zoning bylaws, section 1930.3. Exhibit number 2 is the town zoning bylaws, section 1980.6. Exhibit number 3 is this board's decision just a few weeks ago in the Halverson matter. Exhibit number 4 is a spreadsheet, I believe compiled by Dean, detailing permits that have been obtained in the Beaver Creek neighborhood. Exhibit 5 is a number of different photographs. Most of them are aerial maps. Some of them are street-level photographs. They're labeled exhibits 5A through 5J. And then exhibit number 6 is the building permit for the shed in my yard that I mentioned previously. So I guess for the sake of formality, I would move those into evidence if the board would permit.
I'll have no problem with those being entered into evidence. Do you have any objection to that, sir?
I'll just go through them one by one.
Would you
if I
please
can.
identify yourself for the record?
No problem, Mr. Chair. My name's Ed Adrian. I'm with the firm of Monahan, Safar and Dusham, and I'm an attorney there. And if I can, Mr. Chair, starting with Exhibit 1, we have no problem with that. Exhibit 2, no problem. Exhibit 3, no problem. Exhibit number 4, we'd ask for a proffer of relevancy.
Okay, so you're asking us to consider whether or not this is a relevant document? It's kind of hard for us to say without seeing it.
Exhibit number-
Spreadsheet of permits obtained in Beaver.
Okay. And your reason for
So-
questioning the relevancy, sir?
So there's a permit application appeal that's before the board. What may or may not have happened in any other particular case, whether there's a permit that was granted, whether there's something that's non-conforming, whether there's something that's illegal, or a combination of the above, is not relevant to what the board is considering here today. What the board's sole task is to look at the permit and apply the bylaws in this singular case. If we were in court and this was some type of, this is a complete hypothetical, I just want to make sure the board's clear, but if there was some type of discrimination appeal saying that, the homeowner was discriminated on and they wanted to show a pattern of discrimination, something like that might be appropriate. But in respect to what the board is looking at today, they're looking at the 4 corners of the application and they're looking at the relevant law to make sure that it meets that. So that's why our position is anything that may or may not have been done in the past is in respect to permitting or existing structures isn't relevant.
Okay. Any of my lawyer colleagues on the board have anything to say with regard to that?
I'm not a lawyer, but I have a question.
Okay.
Many times we look to understand the flavor of the neighborhood and what's going on around it. I
I'm
understand
not sure, this
a
isn't
specific
an
point.
appeal, Jeff, this really isn't an application.
Yeah,
And we really do have to kind of focus in on the application itself and the bylaws that apply to it. So, I think, we can take in a lot of evidence, whether or not the board uses that evidence and as part of their deliberation or in consideration of our decision. That's up to us.
Yeah, my concern would,
I'm sorry, can we take judicial notice of our own decisions?
If I may, I don't think this is, and certainly my colleague can offer something to the country, but I don't think this is decisions per se. These are structures that are there. Some of them, there may have been decisions on, other ones there may not have been decisions on. I guess we haven't heard from a proffer as to why it should be admitted. I'm certainly happy to hear that and respond if appropriate.
All right, we'll give them that opportunity.
So these are decisions of the town zoning officer, who is a party here, when viewed in conjunction with
Hang on
the...
one second, this is a decisions by this particular town officer or a town officer?
I'm assuming based on her biographical pre-filed testimony that some of them would not be by this particular officer, but
Okay.
the party is, of course, the town itself.
Yes.
When viewed in conjunction with the subsequent exhibits, which show various structures. This document shows which of those are permitted and which of those are not permitted. And I think it would be useful to the board to be able to evaluate the interpretation of this particular bylaw with the assistance of how it has actually been interpreted in the past. One of the things, I think, as was mentioned before, that I think is important here with regard to the interpretation of the purpose of the particular bylaw, which is actually, I'll get to that point, listed in the bylaw itself, is, you know, whether that purpose has been accomplished or ignored. And I think this particular exhibit would assist the board in making that determination.
Okay. Any other board members have any thoughts and feelings on this?
I would say strictly they're probably not decisions, that it's a summary of outcomes perhaps. And
Right.
that the risk of us admitting it into evidence is that we will use it as Jeff has suggested we will, which is to say, oh, this is what we did
It's a trend
before.
here. I mean, really, in order to do it correctly, I think we would need to look at the decisions themselves. And I really think we need to focus on the application, that being the appeal, and the relevant and pertinent zoning bylaws.
Can I make a point? It's somewhat of a digression, but I requested those decisions from the town. There has been quite a bit of back and forth over what the town was and wasn't willing to provide. I started requesting materials for this hearing back in July. It's taken, in some instances, weeks for me to get items, and more recently I have not been provided anything. So the town's attorney in this matter initially agreed that we would have a deadline for providing items of 5 p.m. yesterday. He personally agreed that these items would be provided by way of email. That position then changed after 5 p.m. yesterday, saying that the town had no obligation to provide these items. In one particular email, the zoning officer who will testify mentioned that she had started to compile some of this information. The town's attorney indicated in his email that he had actually directed her to stop compiling that information, which is the information that you just said you would prefer to see, and that they wouldn't be providing anything. So,
Aren't these decisions, if I'm not mistaken, are matters of public record?
Yeah, I think they are public records.
Why can't the town provide them to a town citizen?
Sure, I'd be happy to address that. So, just as a little bit of background, I became involved in this case on the 13th. Today is the 20th. My understanding is, at least the first indication that I have that these were requested was on the 13th. There's a process that this board, I'm sure that you're aware of, this on-the-record review is a much more formalized process than just handing over information when somebody demands it. I'm not here to weigh in on the merits of that process, but as an attorney, like my colleague, I need to follow the process. So in a normal discovery situation or in most administrative situations, and perhaps those of you that have been in them, the formalized ones have experienced this, is there's a pre-hearing conference which your rules provide for, and there's a schedule set up. So instead, what I was presented with was a demand for a very voluminous amount of information within a week that I deemed ultimately wasn't relevant to the proceedings. In a litigation situation, the public records law, our position is, and I think the case law will support, is inapplicable until that litigation is determined or decided. So those records are essentially frozen. They become part of the discovery process within the litigation, and then once litigation's over, they resume as public records. So I will say that we agreed that 5 p.m. yesterday would be the deadline. We provided everything we planned on using before 5 p.m. yesterday. I believe my colleague did as well. But as far as things that were irrelevant and that were extraneous and that were burdensome, I made the decision to instruct the town not to provide those. There's a process before the board for requesting those, And in fact, I told Mr. Burris I'd be more than happy to agree to a continuance if he felt that he was constrained for time, or that if he needed the opportunity to file a motion with the board in order those compelled, and then rather than just have you try and decide on the spot, we could have, again, a process for discussing that. So,
So there was an offer, an opportunity to continue this
absolutely.
in order to move the discovery process along and to obtain the information you were looking for. That offer was made?
Is that a question directed to me?
sir.
Yes, that was made. I think my response would be, at least the email that we previously referred to indicated that some of this information had already been compiled. It would have been just a click of a button to email it over to me. I think it's sort of an intentional withholding of this information to try to disadvantage.
Well, I don't want to get into, sir, I would really like to try to focus on the appeal, on your application, on the pertinent zoning bylaws that pertain to you. So I think, at this point, I think I'd like to withhold that document from admittance into evidence.
Just to make it clear, I pre-labeled these, so there will be a gap in the numbering of the.
Understood. Is anybody opposed to that, just holding this off?
No.
Okay, very good. And you had an.
Wanted to finish the last two, Mr. Chair. I'm
Yes, sir.
sorry. And I apologize for the formality. I'm just trying to work within the system.
I understand, I understand.
I just, the photographs, I assume those are the ones that you sent me yesterday?
There are.
No, I'll take your word for it. I just want to, there's nothing else in there. Or there is something else in there.
3 additional.
All right, we'll just take a quick look to review these. I don't have any problems with those
Okay.
additions to that, so. We won't object to number 5, and then number 6 goes back to the same objection as to number 4, but because it's actually on this property, and I think that its value is 0, but we're not going to object to it in the interest of efficiency.
Thank you, sir. Okay, then we will admit those items into evidence.
Thank you.
And I take it there's enough copies to distribute to everybody, or not?
It's, a single
These are single copies.
copy that I thought would be sort of the formal exhibit, but there certainly are a number of different exhibits that can be viewed in sequential or out of order.
All right.
I can keep them in an envelope or a folder I'm calling accepted exhibits,
Okay.
and we'll pass those down.
Very good. So we'll continue then. We got off the rails there, so does anybody else have any, Mr. Adrian, do you have anything that you would like to admit into evidence as well?
Well, I believe the board's been provided with the pre-filed testimony of Caitlin and the exhibits attached to that. We would move for the admission of that pre-filed testimony and exhibits A through F.
I don't have any objection to anything. The board is
Okay.
welcome to consider what it
I
feels
assume
appropriate.
everyone here has had a look at those. And there seems to be no objections, so does anybody on the board have any objections to admitting this evidence? Then we will enter those in. If you would, please.
One clarification, one thing I noticed is that the copy of the zoning regulations did not include the maps. I don't think either party is prejudiced by the addition of the maps that are included with the regs typically. So if the board wishes, I made copies of the maps when I noticed that, but if it doesn't care, then we'll leave them out.
Does anybody have an objection to an addendum of adding that?
I would think the board takes official notice of its own regulations, but
Yeah, we
Well,
do.
you could admit-
For a matter of convenience, I don't think it would be such a bad idea. Everyone all right with that? So we will then consider that and entered into our exhibits. Thank you, Dean. Sir,
Thank you. So I'll sort of give the 30,000-foot overview of my position, and then I'll delve further into the details. I think first, the controlling bylaw, which I think we actually agree on based on the zoning officer's pre-filed testimony, is section 1930.3 subsection A3, which establishes a 50-foot rear yard setback for the periphery of the Beaver Creek neighborhood. This would apply to the rear of my yard. Just for the record, the lot at 499 Beaver Creek is on the north of the Beaver Creek neighborhood. The house faces south, so the rear yard would be bordering the northern perimeter of the Beaver Creek neighborhood. That being said, 1980.6 makes an exception for fences in yard setbacks. So 1930.3A3 says this is a yard setback, and then 1980.6 says there's an exception for the yard setbacks. I think this is a relatively straightforward issue for the board, but if the board disagrees with that interpretation, there are three additional points I would make. First, at worst, the bylaws favor approval of the fence, and at best, they're wildly ambiguous in this respect. Where something is ambiguous, I think it's clear that, based on state law, the landowner would be favored. Second, the final motion approving the Beaver Creek neighborhood back in, I believe it was 1983, excluded homes from the yard setback, and they specifically used the word homes, which is different from the language of the bylaw, which excludes structures from the setback. It didn't say structures, it said homes, and I think that was deliberate. Then third, if you look at the Beaver Creek neighborhood as a whole, and also other planned unit developments that are similar in nature in town that have identical applicable setbacks, there are countless structures, fences, sheds, decks, just countless structures within this peripheral setback, to use the language the town uses. In my own yard, there is a shed 20 feet from the boundary that was properly permitted. My next door neighbors have a fence that I pass. I could almost touch it every day that would violate the setback, albeit a different setback. In the photographs, which I'll get into further, there are numerous fences that are in the setback. Some of them are peripheral in nature. And so I think the board can decide this just based on a plain reading of the bylaw in conjunction with its interpretation in Halverson. But if it disagrees, then I would suggest those are three other reasons why this could be decided in my favor. In the Halverson decision, the board noted that it recognized that 1980.6 permitted fences within, and it emphasized, quote, yard setbacks. The board then said, we place emphasis on the phrase yard setbacks because we read this exception literally, which is to say that it pertains only to setback requirements derived from a yard. In that particular case, you said that because there was a lakeshore overlay district, it wasn't applicable. That doesn't apply here. The question just is whether this particular setback is a yard setback. And I think we know we're dealing with a yard setback because the bylaw says it's a yard setback. Your decision continued by saying, quote, as noted above, to qualify for exception, such setback requirement must be one involving a measurement from a property line or a street right-of-way edge. The setback here obviously is a measurement from a property line, so it obviously qualifies for the exception. If you look to 1930.3A3, it establishes quote, minimum side and rear yard setbacks, and this is what is relevant to my application. I think the zoning officer agrees with that. This is where 1980.6 kicks in and says that fences may be placed within yard setbacks. The only limitation is that sight lines onto roads and drives remain unobstructed. That isn't an issue here. Just for the record, this particular lot is somewhat narrow at the front and larger at the back. It's further V-shaped based on the vegetation that is found on either border. And so there's actually a very narrow gap where the driveway enters, and the house is set way to the rear of the lot. So neither neighbor could see the fence, and it might be visible from the road, just a few feet of it, if there's no car in the driveway blocking the view. But if there, at most, there would be a few feet visible from the road. So this is really a fence that no one's going to see. And again, the neighbors and the homeowners association have approved the fence. There's a goal stated in this particular section, and it is to, quote, minimize adverse effects on surrounding areas. I think that makes clear why a fence would be accepted from the prohibition on structures, because if you want to minimize adverse effects on surrounding areas in a neighborhood where there are going to be kids and pets, you put up a fence to make sure that they stay in the neighborhood instead of going out and creating adverse effects on the surrounding areas. Now, I think you're going to hear that the subsequent language in 1930, 8.3, reads, pertaining to the periphery. And I would suggest to you that just because a yard setback pertains to a periphery doesn't make it a yard setback. The town's argument is essentially, yeah, that's what it says, but that's not what it means. And I think what it says is what it is. I think this is decisive in my view, but if the board disagrees, I don't think anyone could be faulted for saying that the bylaws in this respect are incredibly vague and unclear. There is wildly different terminology that is not defined and quite imprecise. And as I mentioned, I think Vermont state law is clear that where there is clear ambiguity as to the meaning of a particular term, then the particular ambiguity should be resolved in favor of the landowner, which of course would be myself and my wife. I don't want to cut her short. I'll move on to the motion of approval, which I think the board also has in front of it. Everyone knew the difference between homes and structures when that was approved. In the particular approval, it even cites the bylaw that says structures, but it uses different language.
Sorry, when you say motion for approval, what are you referring to?
So the Beaver Creek development was, I think back then, it was, as I understand it, a different process than is utilized now. And there was a final motion of approval that was sort of the board's indication that the development could be properly permitted and go forward. And there's language in that particular motion of approval that indicates that homes are excluded from the setback, but it doesn't use the phrase structures.
It's Exhibit B.
Yeah.
Yep.
The town's Exhibit B, yes. So that's exactly what I think happened here.
What happened here, sir?
In the past, in this development, there are homes, actually there are homes in the periphery too, but at least in the past, new homes have been excluded and structures have been permitted. I think there's no better indication of that than the fact that there's a shed in my yard that violates the 50-foot setback, but was properly permitted. And there are, of course, other items that were permitted throughout the development as well. Looking at the bylaws themselves, the bylaws permit developments to be approved where they don't conform with the setback requirements of the bylaws. And that too is what happened here. The board approved a development using different language than what is contained in the bylaws. And in the motion for approval, it clearly distinguished the fact that it wasn't using the same language as the bylaws because it used the word homes and not structures. And then just to segue into my last point, I think it's clear based on the exhibits, that there has been a number of instances where items have been permitted in this peripheral area, and also that the town has made clear that they don't care if the periphery is violated, because if you pull into the Beaver Creek development, there's a fence a few feet from the setback. I think that's one of the final pictures that I submitted. It might be 5I. So maybe 5 feet from the periphery, one of my neighbors has a fence. That fence goes entirely along the front border of their yard. The next house, they have a fence also on the periphery. 2 houses up, there's another fence on the periphery. So it's clear that this has been the standard that has been employed in the past. I also, just to be clear, I requested information whether there's been any zoning enforcement actions, and maybe we can just inquire at a later point, but I would be interested to know the answer. I still haven't been provided that information. So those are my comments at this point.
Very good. Any board members have any questions or any issues with the testimony at this point? Any clarifications?
Probably, yeah.
Okay.
So you referred us to Halverson. I'm assuming that you're distinguishing that decision because we denied the permit in that decision.
Well, I think the decision is sort of irrelevant because the decision was based on a lakeshore overlay district, and obviously I'm not in a lakeshore overlay district. I'm making a comparison to the reasoning in that decision regarding yard setbacks. I think the board basically said, were it not for this lakeshore overlay district, we'd be dealing with a yard setback. My point is, I'm of course not dealing with a lakeshore overlay district. I'm dealing with a yard setback. You've already resolved that issue. That, in large part, resolves this issue too.
Mark, if I may?
Yes, please, Nora.
I was really puzzled by the language in that 1983 decision, the final plan motion that you referenced, where you talk about the use of the word homes as opposed to structures. And again, my sense is that that document may not have been drafted with the particularity that we draft our bylaws and ordinances. So when I was looking at that, the way that reads now, the pertinent sentence, minimum setbacks of homes along the perimeter of the property shall be 75 feet as per section 1330.2. And if you were to substitute the word for instead of, which may have been the intent of the drafters, it would read, minimum setback for homes along the perimeter of the property shall be 75 feet. If that was the interpretation that we put on this, wouldn't that eliminate the kind of ambiguity or confusion that you say exists?
I don't think it would make any difference, with the utmost respect, of course. The drafters, regardless of whether they use the word for or of, are distinguishing homes from the bylaw, which is cited in the next sentence. They're going out of their way to make clear that there is a rule being set for homes. And if they wanted to say that there was a setback, if they wanted the rule to be there's a setback for homes, they could have just said the bylaw controls, because the bylaw requires that there is a setback that prohibits structures. A home is a structure. And so they didn't need to go out of their way to distinguish homes. They could have just said the bylaw is the rule. Instead, they went out of their way to distinguish homes from the bylaw.
But if my suggestion is correct, that minimum setbacks for homes along the perimeter shall be 75 feet, I mean, that's not ambiguous. I would say that if you own a home along the perimeter, that the 75-foot setback applies.
And it would apply even if they didn't write that.
Okay.
The periphery is, my question is, does the periphery that we're talking about apply in all these other homes Because I suppose there must be some homes where the fence is built on the inside of the area of the
On the
development. So there'll be some fences on the inside, won't there? So where the periphery issue won't apply?
The only one that is included with my exhibits that would be on the inside is the photograph of the white fence that is directly abutting my property. The other 3 fences are indeed on the periphery. One
On or in?
within the 50-yard setback, or 50-foot yard setback.
Thank you.
Precision of language is, of course, important here, so I should be clear with that. The first one is the corner lot on Beaver Creek and Bishop. So the fence runs partially along Bishop Road and then bends around Beaver Creek. The next one is the front yard, which is the periphery that runs up Beaver Creek, and then a few houses further up. There's another that is, again, on the periphery in the front yard. There may be additional fences that are on the interior, but I haven't presented those here.
Okay. Any other questions of the appellant from board members? Okay. Do you have anything else at this point, Mr. Burris?
Nope, I think that summarizes it as best I can.
Mr. Adrian?
Chair, I can posit some questions to Mr. Burris.
Please, if you would like.
Thank you. Mr. Burris, without going into too much detail, what's your training and experience in respect to the interpretation of zoning regulations?
I don't think that's relevant to the board's decision here.
I'd like you to answer the question, please, sir, if you would.
This is the first opportunity I've had to interpret zoning regulations.
Thank you.
And you're familiar what's been admitted as Exhibit F, that was your notice of appeal, is that correct?
It is.
Just so the board's clear, how is the board to reconcile the current bylaws, the 2017 bylaws, in your opinion, with this motion from 1983 and the 1983 bylaws?
So one of the interesting things in the more recent bylaws that I think would be more favorable to my particular request here is that the current bylaws explicitly note that a development can be permitted appropriately and alter the existing setback requirements. And so I think that is one among a number of different interpretations, or distinctions, rather.
I'm sorry, say that again, that it can alter the existing zoning requirements?
So if I could just request from the board, the exhibit that I filed is the town bylaw 19, thank you,
Sorry,
1930.3. So in 1930.3A, the bylaw says, however, and I'll quote here, however, the Development Review Board may establish alternative setback standards such as zero lot lines as part of the PUD R subdivision approval if justified by the overall design of the development and consistent with the development objections set forth in the town plan. So that is essentially, I don't believe that was, I don't know for sure, but I don't know that that was present back in the 80s. And that is essentially approving what the board did when it granted the motion of approval. It's saying that change to the rules where they're exempting anything other than homes even though it violates the bylaws, it's okay.
That's if they're approving a new PUD, right? That's not if
Yeah.
there's an existing,
Yeah, I
an
don't- the rel-
existing PUD. Oh, sorry.
I'm sorry, yeah, I'm questioning the relevance of that.
Well,
Go
if the
ahead.
chairs question the relevance, then I'm gonna move on. You would agree with me, Mr. Burris, wouldn't you, that we're talking about two separate things here? There's the so-called yard setbacks, and then there's the periphery buffer.
I don't agree with that. The bylaw that is cited by the town as its basis for denial is 1933A, and that is a yard setback. It uses the word yard setback. So I think it's clear it's a yard setback.
Well, let's break that down. So I'm looking at 1930.3A3. That specifically states, and you correct me if I'm reading this wrong, with the exception of structures existing on March 17, 2009, this perimeter buffer zone must be kept free of buildings, structures, parking areas, and roadways except as needed to access the parcel, and, in the conjunctive you'll agree, must be landscaped, screened, or protected by natural features so that adverse effects on surrounding areas are minimized. So you agree that that's the current bylaw, correct?
Yes.
Okay, and you agree that it uses the term perimeter buffer, correct?
The next portion of it does.
I'm looking at 1930.3A3, this perimeter buffer zone.
I think that's a separate sentence or clause than the one that sets the yard setback.
Well, I know that, but it's applicable to both, right? Because there's the perimeter, and then if the perimeter doesn't apply, there's a yard buffer, correct? In other words, if the house is sitting on the perimeter buffer applies. Would you agree with that?
No, there's no such thing as a perimeter buffer.
Okay, let's explore that. Have you looked at the definitions of what a buffer is in the zoning bylaws?
I have.
Okay, what's the definition of a buffer?
I don't think I can quote that. The board certainly would know better than I.
So we're talking about a fence, correct? So why are we talking about houses?
Well, we're talking about, right now, we're talking about the buffer as to where people could build the fence.
Okay, so we're done with houses now?
Well,
Just
that was
talking about
Mr. Burris's
structures.
testimony. We're talking about, we'll redirect when the town's witness comes on. But as far as now, we're just exploring a little bit about what Mr. Burris was discussing about whether or not there's actually two separate qualifications or requirements or a single one. Is that,
Keep it to the,
I think the
keep it
language-
summarized.
the language-
You're gonna lose us and
The
then-
language here is structure,
okay.
okay?
So you would agree with me that the bylaws define a buffer and the bylaws define a setback? Those are two separate definitions.
Yes.
Okay,
Well, I think, yes, that's correct.
okay. And that, those are in the definition section?
Correct.
Okay, and that in the section that we were just discussing, 1930, there's requirements for that periphery buffer distance, and there's a yard setback requirement distance.
I think in this particular case, those two are, there is no peripheral distance, there's a yard setback.
Well, no, there's actually, it's the opposite.
I think you're
In
asking a
respect to the
question.
back, it's the periphery distance that is applicable, not the yard setback that's applicable, because your backyard is the periphery of the PUD.
Mr. Chair, aren't we listening to legal argument as
Yeah,
opposed
I mean,
to?
So, yeah,
Okay,
let's get some testimony going here, let's try to keep it more
Remember your
evidence-based, and,
okay, all right, sorry.
okay? And if you guys, I mean, one thing that comes to mind, and I'll throw this out there right now, so we don't get all wrapped around the axle and a lot of legal argument, we could certainly, the thought is to not close the hearing, and if you guys want to file some post-hearing memorandums of law of some sort, and that we could consider at a later date, prepare that. It seems like this thing got rushed a little bit, okay? And I'd rather not get into the technical legal arguments. I'd rather just try to take the testimony and the evidence and leave it at that, and continue with our examination of, I assume that's Ms. Mitchell is going to take the stand at some point.
She will, and I totally appreciate the fact that you don't want to get into legal argument. So my conundrum, just so you know, is the whole thing is about legal argument, because there's really no dispute as to where the house is located.
Indeed it is, and I think maybe let's, instead of getting it into a question and answer situation, maybe you guys can each state your positions, and then we'll take that into consideration.
I mean, I think we're in the middle of cross-examination. It's just that we got a bit caught up in almost
Yeah.
arguing with
Yeah,
the witness.
so let's just keep it on a little higher level than,
Okay.
When you did establish that, yes, buffer and setback are distinguished, are defined separately. I think that's what we were.
I understand, and again, I really do apologize.
Yep.
It's an unusual situation
It
as
is.
far as the structure goes. Let me just see if I can shorten things up a little bit, because I know that's where the board would like to head. So in respect to your appeal, you didn't mention it in your testimony, but it is in your notice of appeal, which the board has before it. Why do you think the doctrine of necessity is applicable in this instance?
So I recognize the board has made clear it doesn't consider safety as an issue, but in terms of keeping small children safe, it would be, I think, necessary to have a fence. It's impossible to watch multiple children all at once, and so I think from a safety perspective, it's necessary. Fully recognize that may,
Can I ask you a question, sir? How far is the rear of your building from the periphery buffer in the yard setback? Because
less than 70 feet.
what we have
Less
here,
75 feet.
what we have here is, I can't tell by what we've been given as far as distances.
Sure.
Just, if you can give me a rough idea
Of
of
course.
where you are, help me get a perspective of that, please.
So the distance, as I was told by the zoning officer, between the rear deck and the northern rear boundary is less than 75 feet. So in terms of necessity, it wouldn't make sense, it wouldn't be possible to build a fence 50 feet off of the boundary, because then you'd be just a few feet away from the house.
Well, less than 75 feet, there could be 74 feet, so I get your point. Thank you, sir. Go ahead, Mr. Adrian. Did he answer your question satisfactorily, or?
I think I understand where the board wants us to go, so I'm trying to shape the testimony around that.
Okay, thank you.
Getting to your testimony regarding the final plan motion, you would agree that that final plan has to do with the build-out of the PUD, correct?
I'm not sure what you mean by the build-out of the PUD.
In other words, it's granted to build the houses that are there. You wouldn't argue that that controls how that particular parcel of land is going to be developed completely into the future. In other words, that 2 or 3 page document should take the place of any zoning regulations or bylaws.
So with regard to the final plat that was presented with that motion, I think it would, in some respects, be an approval of that particular plat. And in addition, it would set the rules for the use of the neighborhood.
But you would agree with me that that motion, we'll call it, doesn't mention fences at all?
I agree, yeah.
And so you would also agree that there needs to be something that directs us to how we regulate fences?
Well, I think the way they used the language was sort of the opposite. You could say, everything is okay except, or you could say, nothing is okay except. And in this particular instance, rather than saying, these things are not permitted, they said, this is, in this particular instance, they said, homes are excluded, and left out everything else.
Well, what they said was, and tell me if you disagree with this statement, they said, under phasing in of building the houses, it's under the phasing section, there needs to be a minimum setback of homes from the perimeter of the property of 75 feet.
That wasn't the section that I believed was relevant here.
What's this, I think that's, you're talking about this is Town Exhibit B. I'm going to hand it to you.
I've got a copy, thank you.
If you can find it in a section other than phasing in of houses, please direct the board to that section.
I'm sorry, what am I looking for?
What I just read, the minimum setback of homes along the perimeter of the property shall be 75 feet. That's under the phasing in of the building of house sections under the PUD grant or motion, or whatever you want to call it, from 1983.
So my interpretation would be that when there's a phasing in, houses should be set back 75 feet.
Well, hold on a second. That's not the question. The question is you said it wasn't in the phasing section, it was in a different section. I wanted you to show that.
Yes, Jeff.
How's this related to fences?
Well, again,
If I may, we would agree that it's not related to
You're right.
fences, but we
It's
have to
homes.
counter his argument because it's an
I'm asking the chairman, how is this related to fences? And
it's not necessary, but it is part of his argument, Jeff, as far as the.
I'm having a tough time drawing a relationship between a fence and a house. They're
Well-
structures, I get that.
But part of his argument is based on, unfortunately, the use of the word home versus structure versus buildings.
Can I just briefly
Yep,
respond?
briefly respond, please.
My point is that a fence is not a home, and it's that simple.
Okay, great.
Okay, good, thank you.
That's all we have, thank you.
All right. So, I take, are you going to cross-examine or have a question, Ms. Mitchell?
I'll try to be as brief as possible
If you
and
will, please.
relevant to the issues.
Yep.
But I would like to ask a few questions.
Thank you. I'm sorry? I can't hear you.
I'm trying to whisper. I was just
Fine, you know,
Usually, but I guess maybe we would just confirm that Caitlin's testimony, she would confirm it first and see if there's any.
If
as
you want
far
to
as
do
her
the
pre-
preliminaries, I'm
her-
happy to.
Her pre-filed testimony, is that what you're asking me about?
Yeah, that's what I'm asking.
Right.
Just to confirm that it's all true and correct and whether she has any.
Well, I think that's in the
Before we do
document.
cross-examination.
All right,
Sorry, just-
Ms. Mitchell, is your pre-filed testimony a fair and accurate description of your testimony?
Yes.
Yes, thank you. Okay. If you would, please, sir.
Thank you. When you made this particular decision, did you consult anything other than the bylaws, any legal cases or anything of that nature?
Nothing legal. I consulted the bylaws and the final plan motion and the bylaws in effect at the time.
And you're not a lawyer?
No.
And with regard to the bylaws themselves, you'd agree that there are definitions.
Yes.
And the definitions are very important to interpreting the bylaws. Would you agree that there is a definition for yard
Yes.
and a definition for setback?
Mhm.
And would you agree that there are definitions for rear yard and front yard and side yard?
Yes.
Would you agree that there is no definition for periphery,
Yes.
no definition for periphery buffer,
Right.
no definition for perimeter buffer?
Mhm.
Is a
Oh, yes,
periphery,
sorry. I didn't know.
is a periphery buffer the same as a perimeter buffer?
It would appear they're used interchangeably in the bylaws. And then there's just a definition for buffer, which I would gather grasp both of those.
So what makes you think they're the same?
The context in which they're used in the bylaws.
Is there, is a periphery buffer the same as a yard setback in the periphery?
Periphery buffer. So well, I don't think I should say I think. So in here, it says there's side and rear setbacks pertaining to the periphery. So I think there are setbacks, yard setbacks specifically for the periphery. And then I think it goes on to say that yard requirements for lots within the PUD that aren't encompassed by the periphery have separate yard setbacks. So I think they're distinguishable.
So there's a difference between yard setback in the periphery and periphery buffer. So my question is there a difference between the phrase yard setback in the periphery and the phrase periphery buffer? And was your answer, it's distinguishable?
Right, yeah, so I think in here, it says, I think I'm just being maybe a little bit redundant, so I think the language says side and rear yard setbacks in relation to a periphery, so the setbacks that are observed when there's a periphery buffer in place.
I don't mean to interrupt, but
Sorry, yep.
I think the board can read the bylaw.
Mhm.
Just, is the answer yes or no? Is it the same or is it different?
Restate the question.
Yeah, I think I,
Let's make it a yes/no question
Okay.
and give
Is-
you a yes/no answer.
I'll repeat the question. Is a yard setback in the periphery the same thing as a periphery buffer?
no, if I'm understanding you correctly.
Okay, and is a yard setback in the periphery the same thing as a perimeter buffer?
I'll go back to say that perimeter and periphery are used interchangeably,
So
so I
in
would
this
say no.
particular, so, no, there is no difference.
I think we've established that the perimeter and periphery, the words in the bylaw are used interchangeably.
And you testified before this board on August 2nd. Is that correct?
Is that the Halverson?
Yes, in the
Okay,
Halverson
yeah.
matter. A few weeks ago, and this was regarding a fence for 422 Land's End Lane.
Mhm.
And would you agree that one of the things you said in the hearing was, quote, "I guess I want to make another point that there are structures allowed within the setback. They're specific and listed. If fences were contemplated, they would have been in there." Is that?
I think that's about it.
So that appears to me that you're assessing a general view that if the bylaws intended to use a phrase, then they would use the phrase. Is that fair?
Objection.
It's not really a question, I think.
I'm not even sure I understand.
Yeah, I think you need to,
So,
yeah,
I'll move on.
I'd like to move on, thank you.
Your title is Development Review Board Coordinator and Assistant Zoning Officer.
mhm.
Have you ever issued any zoning violations?
No, notice of violations, as far as I can recall, have been assigned by the town manager, because he's the zoning enforcement officer and just delegated certain duties.
Are you aware of any zoning violations that have been issued in the Beaver Creek neighborhood?
Objection. Relevant.
This,
That's all I've got. Thank you.
thank you. let's do it.
Can I have just 1 second here?
Yes, sir.
Please, sorry. There was some question about, from the chair, about how close the fence is to the property line. Do you have an estimate, or what is your understanding of how close the proposed fence is to the property line?
On the property line.
Like, as close to being right on the property line as one could reasonably expect? Yes?
Yes.
And just so the board's clear, and I don't know how much weight they're going to give this prior motion, but I do want to flesh just one thing out so the board has everything before it. What district is Mr. and Mrs. Burris's property currently in?
New residential.
And what was it in 1983 when the PUD was granted?
Agricultural one.
And there were bylaws in 1983, which Mr. Burris has cited in his notice of appeal that were applicable as well. Is that correct?
Yes.
And you've actually copied a page of those in Exhibit D of your testimony, correct?
Yes.
I'm going to show you, I think the board can take official notice of this, but just so it has the complete record, the rest of that, the bylaw from that period of time, which I've marked as Exhibit H, hoping there won't be any objection, but
So you're entering Exhibit H?
if there's no objection, as the requirements for the Agricultural 1 District in 1983.
Okay.
I'm not sure how the requirements for the agricultural district in 1983 are relevant to my fence in 2017, but if the board wants to consider it, I have no objection to that.
Well, if Mr. Burris wants to stipulate that nothing from 1983 is relevant, I'm happy to stipulate to that. That would make things a lot easiar. But since he brought that up in his notice of appeal, I feel like we need to address it.
I've been handed a document that is detailed and numerous pages. My comment is just I don't know how it's relevant because I haven't had an opportunity to review it.
I understand. Well, and that would be the following page, this is page 37 of the document, or 38?
Well, the page that was provided as part of the initial packet is in respect to the PUD, or it was called something else? PRD.
Right.
From 1983. This talks about the requirements of the Agricultural 1 District in 1983. So I'll proffer this to the board. It discusses the setback requirements, and the only point is that even in 1983, there was periphery requirements and setback requirements, and they were distinguishable then, and they're distinguishable now. That's all we're offering it for. I can't.
Okay.
I mean, I think this is a regulation or bylaw of the town, it was, and I think this isn't something that would normally be admitted into evidence per se. I think for convenience sake, we put a sticker on it, but it's like the law, you know, this is your law. We ask the board to take it under consideration. That's all. And if Mr. Burris wants to obviously digest it and brief it as the chair suggested, we'd be happy to do that as well.
You will have that opportunity.
So we'd ask for the admission of Exhibit H, please.
Okay. Are you objecting to the?
No objection.
Okay, then I would then like to admit that as Exhibit H into the town's documents.
Their exhibits have gone down the table, and
Yep.
I had A through F, but no G, and now H.
Oh,
That's true.
Okay, there is no G.
I'm holding back on G based on
Okay.
previous statements from the chair.
I think that's your prerogative, so we're skipping to H, all right. Thank you, we will enter then Exhibit H. And do you want to attribute that any particular way? It's basically, what article are you referring to
So
in there?
it's Article 3, which is on the first page, the agricultural
Sorry.
one district. And we can, again, brief that, but it's just, if you contrast that with Exhibit D,
Yep.
it's clear, again, in 1983, as it was now, our position is that there are periphery requirements and there are setback requirements, and the two are distinguishable. That's all. And so, sorry,
So noted, thank you.
thank you.
I'm gonna label this one official.
Okay, so where were we? We were,
I'm just thinking whether I need to ask any more questions. I think that covers everything.
okay,
Thank you so much.
good. Do you have any other questions, sir, of Ms. Mitchell?
No, being
Good.
respectful for the board's time, I
Thank you.
think I can end it there.
Board members? Okay,
I do.
all right, well,
Caitlin, I noticed in the response, I'm trying to get back to this. Why didn't you include 1980-6 that specifically calls out exceptions to the setback? Why didn't that come into play when you denied it or even mentioned? I didn't see any mention of it. What's your thoughts on that?
Yeah, so I'm taking the position that it doesn't come into play, much like it didn't come into play with Halverson. While, we're not dealing with an overlay district, we're dealing with something, in my opinion, that is distinguishable from a yard setback. And if you'll entertain it, I'll point to why. So, Mr. Burris was talking about how the DRB does have the authority to change the setback requirements for a PUD. It's kind of one of the benefits of having a PUD. But previous to that section that he referenced, which was down past 1930.3A4, if you go to 1930.1, C, except as limited, well, that doesn't really matter. The DRB may modify applicable area and dimensional requirements, excluding the periphery buffer, simultaneously with the approval of a subdivision plat. So it calls it out separately as something that can't be altered. So it's calling it out as something separate from a setback. And then also just going off of 1930.3A3, I'm sorry, 4, if you read past that portion, yard requirements for lots within the PUD are in areas not encompassed by the periphery buffer. It lays out separate yard requirements when a periphery buffer isn't applicable to that specific lot. So again, they're separate. And yeah, I guess that's why I didn't include it, because I do consider it to be separate from a yard setback. It's a periphery buffer, and while there's language that says side and rear yard setbacks and then goes on to, for periphery buffers, I do think it's distinguishable, and so I don't think the exceptions to the setbacks for fences apply, which was long-winded, sorry.
Okay,
thank you.
Okay.
thanks.
Anything else, Jeff?
No, thank you.
Anyone else? Okay. Dean, you look like you want to say something.
No, I just was wondering if the chair had in mind any kind of, what the next steps in terms of your,
do.
okay.
So I offered to, I understand that this hinges around some points of the law. If and I'll ask you if you'd be interested in doing that. If we do take any more evidence or testimony, we have to leave this, we have to continue the hearing. We can't close the hearing and take any other information from you. We can't, it's not like filing post-hearing memorandums of law. I guess we can't really do that here, so.
You can't?
I don't believe so. That's the advice I got from my staff member.
And that's based on advice from town attorneys,
Okay.
who I've always learned that we ignore at our peril.
Well, so you don't want you can't take post-hearing legal memoranda or post-hearing evidence?
From what I understand, if we close the hearing at this point, we cannot accept any more memorandum, evidence, or anything, testimony pertinent to this case. So, anybody else have an opinion on that, or?
I mean, I don't really see that we need much more input. That would be my thinking.
Okay.
I don't want to speak out of turn, but I think this is, as I said, simple, and I think I've presented the relevant law. The board can read that, and so my preference would be to close it today. In addition, an additional reason why I think it should be concluded today is that from a practical perspective, if the board were to ultimately approve the permit, it has 45 days to do so. The fence contractors in this particular instance require 6 to 8 weeks notice to get on the calendar. And again, if the board approves the permit, then in winter, this can't be constructed when the ground is covered in snow and ice, and there'll be further delay. So my request would be that the board decide this on what has been presented today.
So noted. So, then, both parties have anything else they would like to add before we consider closing the hearing?
If we're going to do that, I'd love to just have a couple minutes for a closing argument, but I'd let my colleague go first if he wants to do something, since it's his burden.
Sure.
I'll be very quick, because I know
Okay.
you probably don't want to hear more about legal jargon when this is really about fences. And I think that's what this is about. This is a small town, as you know. This really is about a fence. And so while we're getting into the weeds about all of this legal language, it is just a fence. But I think the bylaws are clear, and I think based on what you heard from the zoning officer when she agreed that yard setbacks in the periphery are different from perimeter buffers and periphery buffers, that I think further supports the position that I laid out before. And again, just very simply, it is that there's a yard setback in 1933A. It's 50 feet, and it's a yard setback. The bylaw uses the word yard setback. In 1980.6, there's an exception for fences within yard setbacks. And from my read of the bylaws, it's really that simple. And again, if there is any ambiguity, which I think there certainly is, given there is a definition for yard setback, there is a phrase yard setback in the periphery, perimeter buffer, periphery buffer, and as the zoning officer said, sometimes they're used interchangeably, sometimes they're not. That's really open to interpretation. There's really quite a bit of ambiguity, which would favor the landowner under state law. There's the issue of the use of the word homes and the lack of any enforcement, the fact that there are fences all throughout this neighborhood, including in the perimeter buffer, as it's said by the town. So that's really my position.
Thank you.
This case is exactly like the Halverson case, except instead of dealing with a overlay district and a requirement for the regular zoning district, you're dealing with the regular zoning requirement district and a perimeter buffer requirement that's specific to a PUD. That's the waterfront overlay in this case. That's the extra requirement here, which prohibits this type of development. And if you look at the bylaws, they're very clear that the periphery of a PUD was set up to create a buffer. And that buffer has a specific definition in the definition section of the bylaws as to why buffers should exist. And things don't go into the buffers. And if you look at 1930.1, which is the introductory section to PUDs, it specifically says you cannot alter periphery buffers. You can alter other measurements and other requirements, but you can't alter periphery buffers. It's right in your own zoning bylaws. It's sometimes hard to apply the law, especially when it seems like this is a simple case, but you have zoning regulations for a purpose. You want orderly development. If you want to change them, there's a process for that, but it's not piecemeal at a hearing.
Thanks. All right. I would then entertain a motion to close this hearing.
So moved.
All right. Someone like to second that? Seconded by Joanna. All those in favor? Aye. Anybody opposed? Very good. Thank you.
Thank you very much.
You did
I
the best we
appreciate
could.
everyone's time.
Okay. Yes, we do. So, back to our routine configuration. Do you want this exhibit, the folder? Yep, Jeff's got the folder, and I'm keeping H. Okay, so, other business. We have some decisions to sign. Does anybody else have anything else they would like to bring up at this point?
Yeah.
Nope.
Let me get the ABCs here.
So I would then, Kate, do you have anything? Nope. I would entertain a motion to adjourn then.
Second.
I'll make the motion to adjourn. How's that?
Oh, you would entertain.
Good enough.
Sorry.
And we got a
I
second.
thought you were making a motion.
We're not gonna discuss it. Anybody in favor? All in favor?
Aye.
Aye.
Opposed? Okay, we're done.